I'm Hal Cranton. I'm the Dean of Chicago Counsel on behalf of all the faculty and students, and welcome you to the 6th Supreme Court Intellectual Property Conference. And it is amazing to reflect back in terms of generation what their changes have been in terms of the focus and the ascendancy of intellectual property as a topic. A couple of years ago, many schools, including ours, probably had a handful of courses, 4 or 5 courses that were taught. We now offer 50 IP-related courses. We have a center in IP empirical studies, and in a couple weeks we'll be unfolding a innovation center as a pro bono hub at the behest of the Patent and Trademark Office. And the developments at our school, I think, are reflected in many of the schools across the country, but also in the Supreme Court's attention to IP as a subject matter, which of course has brought us all together today. IP certainly now has risen in the level of attention on the court as well as among the academy. So I want to thank our sponsors for recognizing this incredible change: McDonnell, Boehnen, Hulbert, and Berghoff, McAndrews firm, Seyfarth Shaw, Morgan Lewis, Steptoe, Nelson Baumgartner, the Benjamin Franklin Project, and the Templeton Fund as well. So with that, I'm delighted to turn over the dais to Professor Ed Lee, who has been the major domo of this conference for 6 years. Ed.
I don't have too much to say. First of all, let me just say welcome to everybody to start our Supreme Court IP review. I was reflecting on why I get so excited about this conference that we host every year. And I think the basic reason is that the Supreme Court has so much power over IP law and law in general in this country. Just think about the fact that one decision of 9 people in this country can change years of settled practice. So for instance, it can make the word Alice become one of the most feared names among patent holders of software patents. My colleague, who'll be talking later with me in this afternoon about Supreme Court analytics, did a study with several co-authors, and they found that the Supreme Court decisions have moved the market value of publicly traded companies by a net of $140 billion between 1999 and 2014. So that just reflects or confirms the power that the Supreme Court has. So I think what's fun about this conference is finding this year's Alice, so to speak, finding the case of the 5 cases the Supreme Court decided last term that has the biggest impact or will have the biggest impact on its respective IP law, and also trying to find the new upcoming Alice in the cert petitions that are in the pipeline this year. With that introduction, I will just mention a few housekeeping matters. First of all, for those of you who want to access to Wi-Fi, it's on page Roman numeral 6 of the program. You can find the Wi-Fi access. For those of you who are live tweeting or who are on Twitter, the hashtag for Twitter is SCIPR 2015. I also wanted to thank all of the sponsors who have made this conference possible. And later in the conference, I will thank a number of amazing people who will help put on this program this year. But I want to get right to our panel, first panel, which will be talking about the trademark cases. And Sydney Kokjohn of McDonnell Boehnen will be the moderator, and she'll introduce the speakers of this panel. Thank you.
Good morning. Today we're talking about 2 recent Supreme Court trademark cases, Hana Financial versus Hana Bank and B&B Hardware versus Hargis Industries. We have Professor Christine Farley of American University Washington College Law, William J. of Goodwin Procter LLP, who's counsel for B&B Hardware, Bart Lazar of Seyfarth Shaw LLP, Claudia Ray of Kirkland and Ellis, and Mark Mutterperl of Bracewell Giuliani LLP, and he was counsel for the amicus ita in support of Hana Bank. So start with the Hana case. The court's decision rested on its view that whether 2 marks created the same continuing commercial impression depends on an ordinary person or consumer, a task to which juries are best suited. Does anyone disagree? I can start with Christine.
I don't disagree, no, so I'll leave it at that.
Yes. Does anyone else on the panel disagree? If not, what do you think led the Federal Circuit and the Sixth Circuit to take the view that tacking was a legal issue for a judge.
Well, actually, I just want to disagree slightly with this, because one of the things is that, and maybe I'm just being a devil's advocate, but one of the things in trademark law is trying to figure out what is trademarkable subject matter. And when you deal with the Trademark Trial and Appeal Board, or when you're applying for a mark and you're trying to renew it, if you've materially altered your mark in the trademark examining procedures, if you have a design element and the design element is integrated with a mark that it becomes essential, then if you've materially altered your mark, you can't renew it. And to me, that's the equivalent of you shouldn't be able to tack that mark. So with a word mark, I think I agree. But with a design mark, and I was thinking about like an arrow, let's say arrow for moving. And an arrow is sort of a circular arrow and integrated into the word mark. And then they switch into an arrow in forward facing. To me, that would be a materially altered mark. Now, still maybe a jury might be able to say that's the same commercial impression. It's an arrow moving forward. But to me, I don't think, just like in a copyright case, the jury's not supposed to determine copyrightable subject matter. The judge is supposed to do that. And so I look at it in maybe a design element that it shouldn't be a jury issue.
Okay.
Well, I think under the Hana decision, the court has an initial responsibility to determine whether this subject matter is protectable, whether the new mark is properly the subject of a trademark before turning to the tacking analysis and granting summary judgment or denying summary judgment and so forth. But back to your question, Sydney, about whether about the history and how we got to the point where we had courts saying it was a legal issue. If you go back to 1970, the TTAB in the I think it's the Campagna case threw into what had been historically a factual analysis the concept of legal equivalence. And then you get to the Federal Circuit, and in the early 90s in the Van Dyke-Grotti case, where it talked about legal equivalence. And the courts just got hung up on that. And as courts weren't sure what legal equivalence meant, but also if you look at the courts that said tacking is a legal question, they were following the circuit's rule on likelihood of confusion, where some courts said it's factual and some said it's legal. And I think that was just a misguided analysis, because there's a big difference between the tacking analysis of whether marks have the same commercial impression and the multi-factor digits of analysis under likelihood of confusion.
Do you think
but that's how they got there.
Do you think this decision will affect a likelihood of confusion analysis in any courts?
I think the court was very interested in the likelihood of confusion issue, and at oral argument it was really the unaddressed elephant in the room. So yeah, it'll come back someday and be decided.
Can I speak to that? The idea of legal equivalence, I think, is really interesting. And essentially, since I think we're the trademark people speaking to patent and copyright people, in intellectual property, there's always a place to think about a place of comparison. You mentioned in copyright, substantial similarity. In trademark law, since everything is judged against the consumer, it becomes a little bit of a different question, right? So you could look at two marks. I don't know if you wanted to mention the Google.
Yeah, I was getting to that at some point, but go ahead.
The Google mark's recent change, that was simply a change in font, essentially, right? So it's a word mark, but there's a design element, and it's just a change in font. So you could imagine a rule which said, that would be the legal equivalence. I mean, what's the difference in a font? It's the same strange word, it's the same colors in the same order, it's just a different font. And there would be a lot of judicial economy and predictability and consistency in the system if we made these kinds of rules, but I don't know whether a consumer would actually notice that or not notice that, because it's got to be tested against the consumer. So it matters how different is the font, or how ubiquitous is one of those fonts. The real question is a consumer going to kind of key into this change? Is this change part of the distinctive quality of the mark that the consumer really notices? Because if it is, that could be a world of difference. And of course, it matters how well we know Google. We know Google so well. Google could have changed its font and its color and changed the order, and we still would have known Google and not had a problem with it. But Hana Bank, I don't know. What was going on in Hana Bank? Were people paying attention to the English or the Korean, or there's a lot of marketplace and consumer analysis that goes into these questions. So they sound like they can be simple, but I think the basic idea of trademark law is it asks us to check back with the consumer, which is messy, inconsistent, laborious, expensive.
Can I add a word as the person who's not just a trademark lawyer? The Federal Circuit is an ingredient in all of this. Right? The one consistent thing that we see in the Federal Circuit that we'll talk about several times today is the Federal Circuit likes to make things questions of law. The Federal Circuit likes to review things de novo. The Federal Circuit has the same impulse that Bart was voicing. I can look at these marks and I can tell whether they're the same. And I don't really care what the trademark board thought. And the same thing with likelihood of confusion. The Federal Circuit follows de novo review there as well. One trend we see in the Supreme Court is cutting back on what is legal, cutting back on what is reviewed de novo.
Great.
Well, along the lines of the Google case, do you think, are there any other cases that are maybe not such an easy decision that, you mentioned Hana Bank, obviously, but any other cases you can think that anyone can think of coming up that, this issue may apply to?
I think it's tricky when we talk about marks because we've got a couple of different categories of marks. So you can have a registered trademark, or you can have a common law trademark. And of the registered marks, you could have a registered word mark, word plus design, design only. With Google, I think one could argue that the mark itself never changed if you're talking about the word mark, right? The letters that make up Google are still Google. And so you may have changed the font. If they even changed the color, their underlying word mark registration would actually reflect no change at all. So I think when you're talking about it, you really have to look at what is changing and what you're talking about maybe being affected. Common law rights absolutely may be affected by a change that would have potentially no effect on registration at all for a word mark. So.
The classic example is the Morton Salt Girl, who has changed over the decades. And if you look at the most recent and the original, there are quite a few differences, but there is definitely a continuing commercial impression.
Another example is Arm & Hammer. The Arm & Hammer logo has changed significantly over the years, and yet people still think of the same thing. And I think that's what we're getting at when we say the same commercial impression, as Mark said. The Morton Salt Girl, if you look at her, the girl is different, her clothing is different, the umbrella is different, and yet the image that it has in consumers' minds is largely the same.
But part of that is because there have been so many changes over the years. She's been a little bit more modernized each time, and it's just, I don't know how many of us have even looked at the Morton Salt Girl, but we expect some girl with an umbrella there, and we get some girl with an umbrella, and over time there have been some marginal differences that help us make that bridge. I was thinking of another recent big company change is the Starbucks logo has changed so that they just have nobody has a cup here, they just have the mermaid, and it doesn't say Starbucks and coffee in the circle around. And, does it have the same commercial impression on consumers? I'm sure that it does. You could get great survey evidence showing that nobody even noticed that difference. They still are locked on and it's Starbucks. But that's a big difference, actually. You've taken out one whole ring. You've taken out these words. And you would kind of need to know, if you came from Mars and you wanted to know, is this going to have a different commercial impression on consumers or not, you'd need to know how prevalent are mermaids on, fast food places, because if there's a mermaid everywhere, it's probably going to make a big commercial difference to remove that. You'd also need to know how well acquainted are consumers with that trademark. So I think it's very difficult to ask these questions in the abstract.
Yeah, but I can see that at some point too. Look, in law there's exceptions and exceptions to exceptions, and when you're dealing with a rule of law, I mean, words or design elements could change so frequently, or that, and not in a sort of incremental fashion. You can look at potentially like Kentucky Fried Chicken, where they dropped Colonel Sanders completely and went to KFC.
And fried. They dropped
Correct. Right. So is that something that is a continuum that is tacked, should be tacked, and is that something that that the consumer actually carries the same thing?
Well, we've come a long way in a couple of years, because a couple of years ago, probably 98% of all trademark lawyers never heard of tacking.
Yeah.
Right.
Now we
That's
have a
true.
Supreme Court decision on it. And there is, there is guidance now for brand owners on what to do to protect themselves when they have a trademark, and it might be a very famous trademark that they want to change or update. And clearly now brand owners need to identify what the commercial impression is and document the intent to preserve the commercial impression and intent whatever their new logo or new trademark is going to be. And given that it is a factual question, they need to do things, brand owners need to do things like surveys and focus groups and consumer studies and on the old as well as the new, so that they're prepared when they get what could be a challenge when they try to enforce it.
Given that, as you said, 98% of people didn't even know what tacking was 2 years ago, do you think this case will change how you advise clients at all?
Yeah, I think Mark got it right. I mean, I think what you have to do, your root mark is what's important, but at the same time, when you're bringing out a new brand, you may want to maintain that legacy brand for a sufficient period of time. You just don't go like, okay, new brand. You have this transition time where you're maybe co-branding your old and your new, or using different channels, media channels, to focus on different markets, but yet continuing to use the legacy as you transition to the new, so you can establish your intent, and I think establish the continuity of impression and intent to convey a trademark to consumers.
And showing consumers that transition and how the marks have evolved is a great idea.
Do you think the court's decision will affect summary judgment? The court said that a court could decide the issue on summary judgment if the facts, but not if the facts don't warrant it. Do you think that's going to change how the court decides on whether or not the court decides summary judgment?
I think it's really saying to the litigants, here's one more issue you can fight over.
Okay.
I think when we go to brief summary judgment, people more and more are thinking about attacks on the mark. And I'm seeing that as plaintiff and defendant in cases where a lot of the action used to only be on likelihood of confusion. You'd have a presumption of validity if somebody had a registration, but I think people are now more and more going after the marks themselves and looking through the file wrapper for a registration to see if there ever was some kind of change that was approved through tacking that they can then attack and say to the district court, you don't have to accept the examiner's view on this, this really was improper. I've seen that in litigation. And so I think basically what it's telling the litigants is, yeah, that is a fertile area for you to investigate through discovery and try to make something of on summary judgment. I think it's going to make the summary judgment briefing more involved than it is even now. And there's clearly authorization to the district courts to decide this on summary judgment. So you're going to have the brief being written with this case saying you're empowered to do this, Your Honor, and here are all the facts showing you why. And that's going to be just a bonanza, frankly, for survey experts and all of the folks that you would look to build that factual record and support.
Great. I think now we should probably, to make sure we have enough time, move on to the B&B Hardware case. So what effect do you think this decision will have on trademark registration? Do you think that owners will put more resources into these TTAB opposition proceedings, knowing that they might have a preclusive effect?
Yes.
Yes.
How would you advise your clients, given this decision, if they are faced with an opposition or cancellation proceeding?
Just by way of context, the difference has always been that when you're in a cancellation or an opposition proceeding at the TTAB, the net outcome of that might be that either you don't get a registration or you lose a registration that you had, but you don't lose the right to use the mark. You don't get hit with damages for infringement. So the stakes were always much, much lower at the TTAB. You could have a client, as I've had, decide that they're not going to put that much into it and not take it that seriously because they knew that there was no injunction and no damages that were going to come out of that. Now you have to look at that case and say, this could actually be the functional equivalent of a district court infringement action, but with different evidentiary standards where I'm not going to be able to put in my full case. So as a defendant, you might very well decide, I'm going to go take a DJ action in a district court, stay the TTAB decision, and really go full bore. Whereas I was previously looking at a very manageable, relatively low-cost adversarial proceeding that was very limited in terms of its potential outcome. Now you may, as a defendant, have to go for a nuclear option, which I think is very different.
I think we've probably seen the end of the days when parties would file trademark oppositions because they could and it didn't cost much, and file it and do little and hope, in 6 months the case would settle. Now the rules are just different, and it's the stakes are much bigger. So I think potential parties need to focus very quickly on whether they really want to go to the board and with an opposition proceeding, or whether they want to forego it and just file suit, because we're getting much closer in terms of what the costs are going to be and what the analyses will be.
Besides for likelihood of confusion, what are some other issues that the TTAB routinely decides that we could expect to have a preclusive effect?
Well, I think it's fair game for issues of fame of a trademark, dilution, again, an area where you would sometimes the dilution claim would be sort of a tag along to protect the register in a TTAB proceeding, opposition or cancellation. It's priority of use and validity.
All of Section 2, right?
Yeah,
all of the
basically all of Section 2.
registrability of the mark, whether it's distinctive, whether it's generic. I think really anything could be argued to have an issue preclusion. But there are some, I think, clear differences. I think the way the TTAB deals with functionality is quite different than district court, so that might be one in which the argument is raised, but it may not be successful. But I think on other issues of distinctiveness, disparaging, scandalous, these are the exact same tests in the TTAB as they are in federal courts. I think a really good argument could be made that they should have preclusive effect.
And just kind of to relate it to the case itself, long ago in this very long and unhappy litigation, Hargis, the party that wound up losing on preclusion, had prevailed in district court on mere descriptiveness and was trying to use that offensively in the trademark board as a preclusion matter. Preclusion works both ways.
Right.
If you win in district court, you can then preclude the trademark board from disagreeing with that. But descriptiveness, subject to a mark becoming incontestable, but descriptiveness is an excellent example of not just something that can be litigated in both places, but something that you might have a very different approach from these two different tribunals.
Now, did Hargis not seek to stay the TTAB proceeding?
The TTAB proceeding was a case has been sloshing around for a long time, and there have been several different proceedings. The descriptiveness victory that they won in district court, it wound up coming too late for them to use it in the trademark board because the mark had become incontestable, and they didn't ask the district court to cancel the mark.
I think for people who haven't practiced before the TTAB, one of the things is that they're the insiders. They're the ones that are involved in the registering of trademarks. So in some ways, they have a vested interest in protecting the procedural elements of the trademark office, and I think they, from my experience, they have a higher likelihood of, let's say, upholding the validity of a trademark, where, you know, a federal judge, I think, would come at it maybe a little bit more objectively. You know, having registration gives you the prima facie right to validity of the mark, but what does that give you? 50.1%. It doesn't give you 65% validity, 50.1 or 01.
Let me ask you a question. How easy does everybody think it would be to get around issue preclusion by, you know, having different goods, different services, or by not litigating all the issues before the TTAB?
I think easy, and I think in addition to the things you've already mentioned, if you're right, if your prediction is correct that people are going to invest more in the TTAB opposition procedure, they're going to introduce survey evidence, for instance, they're going to come with survey evidence. Since there's not an opportunity to hear live testimony from the survey experts, that could, I mean, if the survey evidence becomes the key fact on the question, whatever the question may be, then you might want to have live testimony. You might want to be able to cross-examine these witnesses, and that you only get the benefit of in trial court.
And I think the nature of the evidence is also important. When you look at the decision, there's a lot of talk about how registration is very important, so people are already incentivized to take it seriously, and how the factors are the same. I worked on the inter amicus brief in B&B, and one of the things we tried to do in that brief was to really parse very closely the real differences between the proceedings. So, for example, with respect to survey evidence, when you do a survey for the TTAB, for word mark, let's say, you literally show a word on a white card, and that's what your stimulus has to be. So a consumer who's being surveyed is looking at word on a card and a word on a card, and how similar do they seem. Whereas if you did that same survey for a federal court litigation, you would show the mark in context. So if it appeared, let's say, on a web page from Amazon, you would print out that page and somebody would see the mark with all of the context in the actual marketplace. It's that kind of difference that I think people are going to play up, and I think this really incentivizes people to look extremely closely not only at factors that are considered, but what goes into proving that factor, and trying to parse that on the issue preclusion argument and show, even if superficially it seems like the same things are being considered, the inputs in terms of the facts are quite different.
And there's also room to, change which goods you seek registration for and which goods you litigate. And before B&B, the Federal Circuit had a case called Abercrombie & Fitch versus Levi Strauss, in which the registration recited huge number, basically everything you could wear, hats, shirts, shoes, you name it. But the litigation was just over jeans, right? A subset of the broader things sought to be registered. But you can argue that while we lost in district court on jeans, maybe there's room for confusion in this broader set of goods. And it goes the other way too. Maybe we lost because somewhere in this broad set of goods we want a registration for, there's confusion, but that might not be for jeans, so let's go litigate about jeans. And then you get to talk about the market for jeans and how the mark looks on the jeans and things like that. And
jeans are not jeans, right?
Right.
I teach two likelihood of confusion cases back to back that are both about wine, and in one case the court says wine is wine is wine, these are the same products, and in the other case, sitting in California, the court says, no, wine is not wine is not wine. These are extremely different, and we can get into the market, I think, a lot much more in litigation.
Right. I mean, the board refuses to look at, whether this is premium wine sold to premium customers or cheap wine sold at Trader Joe's. Mm-hmm. Wine is wine to them.
Mm-hmm. In view of the fact that the TTAB and circuit courts apply different multi-factor tests for likelihood of confusion, the court rejected the argument that preclusion can't apply because of that. Do you agree, or do you think, like you said, that that'll be an issue that's litigated to show why preclusion doesn't apply, that the tests are different?
I think this is why Hargis lost this case. I think the court just saw, okay, we have these different factor tests, and here's 6 factors that the TTAB applied, and here's 6 factors that the 8th Circuit applied, and these factors don't look so different, right? And I think the broader comment about trademark law that comes out of this case is the likelihood of confusion test is really not a test. It really fails as a test. You know, there's not a lot of predictive capacity in the test. There's not a lot of guidelines for the test. You know, it's kind of it prompts you to consider different arguments and different pieces of evidence is all it does. So, you know, the argument that Hargis made was the TTAB doesn't consider the marketplace, but there was a factor that said we consider the marketplace. And then when you drill down, you see a big difference in how the market. So I think as a test, yeah, it's the same, but it's nothing. It's nothing.
Yeah, I mean, even if you can parse out what different circuits do and say, here's the Third Circuit's test, and here's the Ninth Circuit's test, and here even why they lead to different outcomes. Mm-hmm. The point for preclusion purposes is the circuits don't get to change what the statute is, mm-hmm. right? You know, like the analogy we used in our brief was Galapagos finches, right? Like, you know, you can have one finch that goes to a bunch of different islands and eventually it becomes little different species. You don't get to do that with statutes. It's still one statute. And even if the different circuits are doing very different things, that happens all the time. It happens in criminal cases where one circuit thinks that there's an element of the offense mm-hmm. that another circuit thinks doesn't exist. It's still the same statute, still the same crime. And the same for preclusion purposes. That's what you have to look at. Even though, you might, as a trademark litigator, think, I want very much to be in the Ninth Circuit for this case, and not the Eighth Circuit.
And I think,
I was going to say, do we now have a cottage industry that will develop in district courts where we're litigating over issue preclusion, or do we avoid that because parties just skip the TTAB and go directly into court?
I think that's very possible. There's either going to be fights over the preclusion issue or more fights over suspension, over whether now, okay, it's been traditional that you'd always have a district court proceeding and then the TTAB would give in. Maybe they'll fight more about, well, maybe those cases should go on. And when you're choosing about that, I think Claudia makes a real good point about how the TTAB is looking at things in a vacuum and not in reality. And so certain factors in the likelihood of confusion test suddenly become submerged, I think, when you're at the TTAB. Things like differences in the channels of trade, sophistication of the purchaser, the people that you're communicating with. Because in large organizations, your buyer is often much more different levels of sophistication. So they may never encounter a similar mark in connection with similar goods and services simply because it's not either part of their job in the way they buy things, or because they're sophisticated enough to know the difference because of one thing is a software product that costs $500,000 while the other item is $100 to $1,000 service.
And I think that, to Mark's point, I think we're going to see both. I think we're going to see people trying to get out of the TTAB box and putting themselves in district court. And I think for those cases where initially maybe nobody thought it was that big a deal, and then you have a TTAB decision, and then you actually do have something going on in federal court, I think you are going to see fairly intensive litigating over this preclusion issue, because I think people will find themselves in situations where belatedly they realize that it really matters. And so I think you'll see both. What would be interesting is if the TTAB starts taking a different approach to stays than they traditionally have. It's not mandatory that a case be stayed, but I've never had one not be stayed when the request was made. I just, for the first time, had somebody refuse to consent to a stay as a party. And so we're going to be going in asking for a stay without consent, and it'll be interesting to see what the TTAB does. I'm betting that they grant the stay because they have no particular incentive right now to add more to their docket. But we might see that changing if they suddenly see a flood of cases not coming in. And it starts mattering to the people who are employed to do these cases.
So I think there could be a big, we may see a bigger impact in trademark law from this case than from the tacking case. And you've already mentioned more investment in the TTAB, more fighting over the preclusion issue, and there may be some other changes too, depending on what trademark owner we're considering, right? Is it the trademark owner who's using the same mark? Is it the Hargis who's using the same mark in a different industry? They may not register the mark to get caught up in the TTAB system. There may be more waiting and seeing, what results. So there could be a space for less litigation as well. And in addition, I think there could be more appeals of the TTAB decision, not in federal circuit, but in the Eastern District of Virginia, in federal court, where they will have the opportunity with de novo review to review the likelihood of confusion facts and enter and supplement the record with additional facts. So as a person teaching trademark law in DC, I think DC will be the place for trademark law, right? Where there's going to be a lot of action in the TTAB and a lot of action in the Eastern District of Virginia that I think will increase. Both will increase.
It'll be interesting to see what the board does and whether the board reacts at all to the Supreme Court's decision.
And what about Congress? Will anybody ask Congress for a change?
The one change that would affect this, although it's not being motivated by this, is that Congress was considering changing the appellate venue for those cases you're talking about that go to the Eastern District of Virginia, making the appeals go to the Federal Circuit instead of the Fourth Circuit. And the reason for that, could be summed up in the one word: Redskins.
Mm-hmm.
So do you think this decision waters down the de novo standard of review of the TTAB's decisions at all?
I don't think so. I don't think so. I think what Christine suggested is actually you may end up. I guess there could be arguments in a de novo review as to. I think a de novo review is de novo review. There's no preclusive effect there.
Yeah.
So I think actually it
enhances.
I agree with Christine pretty much.
Right. I mean, the Supreme Court had this case involving the Patent Board about 15 years ago. No, I'm sorry, different case. About 5 years ago, in which they said basically, if you put in new evidence, it's a clean slate, and you don't think about the board's decision in a deferential way, and that is very, very rarely used. There's like a single-digit number of appeals to district court in the last couple of years, but that's definitely going to go up.
I know we talked about that the TTAB decisions should start using more survey evidence. Do you believe that those TTAB proceedings are going to become just as expensive as district court proceedings, or will they still be a cheaper option for clients?
I think it's going to be more expensive, as you already heard. So Claudia is saying people aren't even agreeing to what was normally a stay. Oh, I will stay, no problem suspending. I think there'll be more fighting over, the TTAB is opposition or cancellation. It's always been a kind of sleepy proceeding where people work together towards common goals. There's not as much, people aren't move for sanctions because sanctions they're not as powerful in the TTAB. And there's also discovery, and then there's evidence depositions. Mm-hmm. And a lot of times people work together to try to say, yeah, let's save money, let's combine the discovery with the evidence depositions, let's do this in as neat a fashion as possible because we're concerned about our clients and saving money. I think a lot of that's out the door.
I think, I agree. I think TTAB proceedings will become more expensive than they have been. And we may see, for example, fewer stipulations of fact, fewer stipulations of law, more surveys, more discovery. Comparatively, though, I think TTAB cases will still be less expensive than district court proceedings because of the inherent costs involved when you have live witnesses and when you have juries. Those
and to the extent there had already been two litigations, right? A litigation of the registration, litigation over infringement. Even if you're spending more at the TTAB, if that issue is precluded, you may be spending less overall.
Yeah. But I doubt, though, that the cost difference is going to be the motivating factor for people or for companies to give up the opportunity to have live witnesses and to have juries. I just don't think people are going to say, well, I'll give that up because it'll cost less if I go to the board.
So, can I ask? question?
Yes.
I'm wondering what, if any, effect this will have on remedies and injunctions. So if traditionally there had been some low-level litigation about the registrability of the mark on the basis of likelihood of confusion, and then there had been another district court litigation on likelihood of confusion with a much more elaborate record of the consumer, the market, the marketing channels, the reactions, you have a position where the judge can finely tune an injunction, right? Registration is all or nothing, but an injunction is not all or nothing. So the judge could craft a very narrow injunction to alleviate confusion and allow the parties to carry on to the extent they can. Without that trial, won't it be harder for a trial court judge to craft such an injunction? If so, that's a big negative here.
I think potentially if you don't have fact-finding going on in the district court that's really robust. And I think that is something that's going to scare people, because the fact-finding that you do at the TTAB is much more limited, as we've discussed. If that's what then gets imported into the district court, it has preclusive effect when you don't have different, more robust fact-finding. A judge may not feel comfortable being so surgical.
Right.
They may feel like I'm safer on appeal, I'm safer in terms of doing the right thing. The judges are people, and one of the things you try to do when you're putting in summary judgment papers or trying a case is give them the ammunition they need to feel comfortable with the decision you're asking for. I mean, they want to know that this is something they can feel good about as a thoughtful, reasonable decision. And if they're looking at a record that they believe is part of a preclusive decision and yet thin, so that they feel like there are questions that they don't have answers to, there are facts they don't have, they may choose to do less. Sometimes they may choose to do very little in terms of an injunction, either having it be far too broad or far too narrow, that they may feel like there hasn't really been a conflict that's been proven to their satisfaction.
It's a great question, Christine, because I think that judges do learn about cases as the cases are ongoing, and that frames the way in which they're going to enter injunctions and also damages. You know?
Yeah, and you know, usually in a situation where you've likelihood of success on the merits, you presume irreparable harm in a trademark case. But in this kind of situation, where you take a TTAB decision that says there is success on the merits, then I still think the judge has got to look at the world and look at irreparable harm, balance of harm, hardships, whether it's harm to any third parties or to the public. And that, I think a judge would be very careful to take a TTAB decision and just convert it into a broad injunction.
Right, but if there's a damages case, then there's going to be a damages trial, right? And some of that will come in as part of the damages trial. If it's just an injunctive case, then it's going to be up to the judge. Do I want to have a little bench trial on the injunction factors, or do I just want briefing?
Do you think this decision gives the TTAB administrative law judges too much power, or more power than the district court judges?
I think I wouldn't look at it in terms of relative power. I think the decision may preserve the position of the TTAB and the administrative law judges, but I don't know. I mean, we'll see what happens. There may be fewer cases that go to the TTAB, and therefore, in terms of power, less power. And in any event, ultimately, it's the district court judge who is going to have to decide whether or not there is any preclusive effect. So,
there may also be more declaratory judgments brought by the Hargises of the world, right? That, you know, they may quickly figure out that their better venue is in district court, and so then there would be less going to TTAB.
Right, and there are sort of still three things about administrative trademark judges that aren't true of U.S. district judges. Number one, even when they get the first case, this is obviously a question to be fleshed out, but their current practice is they will let you go file a case somewhere else and then put the first case on hold. No U.S. district judge is going to do that. Second is de novo review with new evidence on appeal. And third is that the Federal Circuit reviews, as much as it can de novo, whereas U.S. district judges often are going to have deferential review in the regional circuits.
So I know we kind of touched on this before, but how would you advise your clients to avoid a potentially preclusive effect if they lose? If you're bringing a TTAB action, what do you advise them to do?
I don't advise clients.
Well, I think one of the things is to go with the narrow scope of goods. Even though you do have a registration for a wide variety, they may decide to pick, a lot of times in the TTAB, you're really dealing with people decide to go to the TTAB now, I think, clients, because not as much is at stake, or they're trying to protect their registry. They have a one-word mark, and they want to keep the register clear of two-word marks that are maybe sort of on the outside of their pie. One, I think you're going to advise people maybe not to, maybe there might be some reason not to even go there. And then secondly would be to narrow instead of it's typical in a complaint in an opposition, you just list all the registrations you have. You say these are all the marks that we have for all the goods. Well, maybe be more surgical in what your claim is.
Well, there's one other option for someone who's facing an opposition at the trademark board. If you are willing to modify your registration to some extent, you can take a default in the opposition proceeding. That will have claim preclusive effect on you, which means that you can't have exactly that registration, but it will have no issue preclusive effect in a new either a new registration proceeding with a different registration, or in district court over a different scope of goods and different market. So, and the change might not be terribly drastic. This is more relevant to people who are hoping to register a new mark. They haven't used it. It's an intent to use application. And if you are willing to, monkey with your mark before you go to market, then you may have more options.
It'd be interesting to see if it prompts greater flexibility on the part of the litigants in the TTAB, both sides recognizing there could be a preclusive effect here, to try to sit down and work it out sooner than later. If there could be a modest change that might be made to a mark or to goods and services, for example, you might see people more inclined to enter into coexistence agreements or things that could work it out so that they don't have to go with the nuclear option. Be like B&B and Hargis litigating forever.
Right, because before you know who wins, both of you probably want to avoid that appeal to district court with new evidence. Both of you want to avoid litigation. And, preclusion is a defense, right? Preclusion is something that the litigants have to raise. It can be stipulated away. If the parties want to basically work out that, we're going to settle our differences in this proceeding, come hell or high water, you can do it that way. But you can also leave yourself the option of relitigating by agreement.
So do you expect the parties that lose before the TTAB will argue that the TTAB procedures unduly limited their ability to present evidence on confusion, since the TTAB doesn't allow live testimony?
I think it's possible. I don't know what's happened so far, but I think it's entirely possible that someone will figure out the best strategy to avoid issue preclusion, and that will be the model that's followed, and this maybe has less of an impact. And that may be it.
That's not going to be it. I mean, seriously, the Federal Circuit reviews the TTAB, and the Federal Circuit might someday say, shame on you, you should be doing this differently. But in order to do that, like the rules of the board are promulgated, under the APA, and they're in the Code of Federal Regulations, and the board gets some deference in how it conducts its proceedings. And I think it's very difficult to read the Supreme Court's decision and say that this is, in any real number of cases, going to be a ground for deeming the board's proceedings fundamentally unfair and not entitled to preclusive effect.
I think that's right. I mean, you've got a decision that essentially says what they're doing seems to be pretty much okay, and so we're not going to automatically.
Or not, it's pretty much okay, but it could be okay.
Could be okay.
In some cases, it
facially
could be
strike
okay.
us as
It's
outrageous.
Not, exactly, not
right?
facially
Right,
outrageous. That's
right.
I mean, what I think you'd have to do is to say, my case is the unusual case. My case is the case in which, the ability to watch the witness sweat in the witness chair and twitch and, turn red is so important that it rendered the proceeding fundamentally unfair when the administrative trademark judges couldn't see that.
That there was some kind of procedural violation, that the ability, as you said, to see the witness kind of squirm was really very significant, because anybody can put in papers saying anything, but when you're really confronted with all of the material and you get to see the person looking incredible when they give incredible testimony.
Tough argument to make, though, if you voluntarily are in that proceeding.
If
Right.
you what?
If you're voluntarily
You're
in that
not
proceeding, I mean, you do have an option to get out.
Right.
And these witnesses are deposed, right? There are not just discovery depositions, but testimonial depositions, as you said. The board will not, at the moment, accept videotapes of the deposition. But if you wanted to build a record, I think you would have to say, Your Honors, look at this videotape, right? And and your refusal to review this videotape would make the proceeding fundamentally unfair. Here's something tangible about this case that separates it from every case in which you don't want to have a live trial.
So that's intriguing. So do you think in your next significant proceeding, would you move the board to have a video dep? I mean,
you can take a video.
Yeah.
The board just won't look at it.
I know they won't look at it, but still.
You might get a situation where there is then follow-on district court litigation and somebody who was not the petitioner, right, respondent, who tried to stay it, but in the odd case, the TTAB refused to stay. So they were there involuntarily, and they make a record as they go along of all the things they couldn't do, including putting in the videotape of the deposition where the guy was clearly lying, or contrasting the videotape of the discovery deposition with the videotape of the trial deposition, showing how somebody changed their position or changed their demeanor. Going to the district court and putting all that in, that person, I think, will have a credible claim that this was, as applied to me, procedurally unfair, and I didn't get due process here. And here are all the reasons why this process is inherently unfair, because this is what could happen. It may not happen to everybody, but it opens the door to this. But I think that's so unusual a setup, you might have a long wait before that.
Well, and also a method, but I think you put your finger on what would solve the problem before it arises in the preclusion context is, who would watch that videotape is the Eastern District of Virginia, right? If you would just go to the district court, someone would watch your videotape.
Yeah.
And so to say there should be no preclusion because nobody would watch my videotape, it does raise the question, why didn't you appeal to the Eastern District of Virginia and show them the videotape?
Right.
I think we have around 5 minutes left, so I think we'll open it up to the audience for questions. Does anyone have any questions for the panelists?
So I have a question, and it's not exactly about, it's about how important TTAB cancellation and opposition proceedings will be in the future, and based on Judge Moore's concurrence in Raytam, where she sort of makes this remark that if it's not registrable, or that 43A unfair competition claims are only getting for marks that are clearly unregistered. So I was sort of curious, that wasn't sort of
Wrong. She's wrong.
so I sort of that's correct, or if there's any way that yours would prove that.
I mean, it's a great question, and I think there's a bigger issue in this in B&B in this question of we've got these dual proceedings, which is in trademark law we have this weirdness which has never been sorted out ever, and it never will be, I guess, of having a registration which kind of means something and it kind of doesn't mean something, and really it's about common law rights, but how do we get common law rights? And so there's this really interesting relationship which doesn't always look the same given the issue involved. And I think Judge Moore is also pressing on that. I think she's wrong, and I know that the INTA amicus committee wrote an amicus brief in that case stating that you do have common law rights to bring in federal court in cases in which a registration has been canceled. So you still have trademark rights without a registration. But I think this is one place where we see this this not fully worked out relationship between the two.
Agreed to is that this is going to increase the amount of litigation in TTAB, and I think that's an institution that probably not that many people are familiar with, except for those of you who are practicing before the board. I think a big question is whether the TTAB has the capacity to sort of get through more litigation, sort of lawyers bringing in more evidence and having something closer to a district court trial in the TTAB. Could you speak to the capacity of the TTAB and how many ALJ judges are there? What's the typical time before this decision in terms of like how quickly they decide cases? And do you expect that this is going to slow things down and create a greater backlog of trademark controversies before the board?
Good question. I think there may actually be fewer cases at the TTAB, but those cases that are brought to the TTAB will become more heavily litigated. But in terms of numbers and statistics, I don't know.
I mean, the TTAB can do complicated cases with huge records, and the Black Horse case is just one example of that. So they have the capacity to do it, I think. It is, by its nature, it's a different operation. And I think that will be the question, if there's a trade-off between number of cases, but the cases are more robust.
And they're not terribly fast right now. And there is sort of a pilot project to try and move some cases through more quickly. But compared to district court litigation, the TTAB advantage has never been speed, it's been simplicity.
And they're going to have to figure out how to deal with discovery disputes and some of the other things that happen in litigation that don't generally happen at the board.
I think we have time for one more question.
So you all touched on how this may have an effect on damages, but I was wondering if you guys could talk specifically about how it might affect intent. So let's say your client, loses an opposition when they filed a 1B application, but then they decide, okay, we can't get the registration, but I still want to use this mark. Do you think that the decision of the TTAB will affect how a court would rule in terms of their intentional infringement?
Good question.
I think so. Just because there's actually a decision, even though it's not a decision from a district court, it's a decision from a judicial body that's endorsed by the Supreme Court that says, hey, this is your use of this mark as infringement. Now, maybe there's an argument if they applied for certain goods and they're using the mark in different goods or services, and if you can get a legal opinion that says that, that would encourage, I think, that mark owner to have a pocket opinion that says, that distinguishes the TTAB decision somehow to avoid an intentional infringement. That would be the best defense. But I think it'd be tough. Road to hoe.
Yeah, and I think that's a great question, because I think it's going to become much scarier. It's no longer a matter of something that you saw come up in a search report, but you have a good faith belief that there is no conflict, and you proceed on that basis. Then you end up in an infringement case, and you say, well, just because I knew about them doesn't mean that I knew there was an issue. I don't see how you can make that statement when the TTAB has decided there's an issue, unless you've done something like change the goods or change the mark somehow that you had originally applied for and been unsuccessful with.
Yeah, it's like the advice we give to clients. Sometimes clients ask for. Don't ever ask someone for permission if your response to no is going to be you're going to continue you're going to use the mark anyway, because that's that's the intent.
And that's essentially what would happen, I think. And they wouldn't, the party they wouldn't be asking permission of is the U.S. government, right? And so there's going to be fewer registrations, which is not necessarily a good outcome, right, for those parties.
It looks like our time is up. Sorry to interrupt, but thank you to all our panelists.